Our topic for this episode is all about criminal liability. Criminal liability refers to the penalty of imprisonment or payment of fine or both that may be imposed by a trial court to an accused that will be found guilty or who will plead guilty in the commission of a crime. Penalties of imprisonment that may be imposed for violation of the revised penal code are enumerated in Article 27. These are reclusion perpetua, reclusion temporal, prison mayor, prison correctional, arresto mayor, arresto menor, and bond to keep the peace. Fines are those enumerated under Article 26 of the revised penal code, which are classified as light, correctional, or afflictive depending on the amount of fine. For the purpose of this study, we will be discussing criminal liability based on Article 4 of the revised penal code. The law says that criminal liability shall be incurred, 1. by any person committing a felony or delito, although the act done be different from that which he intended, and 2. by any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. The first paragraph of Article 4 introduces instances or situations where a person may incur criminal liability although the wrongful act done be different from that which he intended. These are error in personae or mistake in the identity of the victim, aberratio ictus or mistake in the blow, and praeter intentionem or injurious result is greater than what was intended. Error in personae happens if the accused injured a person who is not the intended victim. For example, A planned to kill B. One night, A waited for B in a dark portion of an alley where B usually passes by at night when going home late from work. When A noticed the person approaching and thinking that it was B, A stabbed the person several times, but was surprised later to find out that the person he killed is not B, but it was C instead. In this instance, A may still be criminally liable for the death of B. We call this situation as error in personae. Aberratio ictus happens when who was hit or injured by the offender was not his intended victim. For example, D with intent to kill shoots E, but E was not hit by the bullet, and the same bullet hit another person who died as a consequence. In this example, D may still be criminally liable for the death caused to the unintended victim. This is called aberratio ictus. Praeter intentionem happens if the unlawful act of the offender resulted to a greater felony than that what he intended. For example, X suddenly pushed Y on a river just for fun. However, Y does not know how to swim. As a result, Y drowned instead. In this example, X may still be criminally liable for the ensuing death of Y. That is called praeter intentionem. For a person to be criminally liable under paragraph 1 of Article 4, the following requisites must be present. First, that an intentional felony has been committed, and second, that the wrong done to the aggrieved party be the direct, natural, and logical consequences of the felony committed. In short, the unlawful act of the offender must be the proximate cause why the felony was committed. If there was an effective intervening cause or other reason other than the person's unlawful act that caused the ensuing felony, then the person may be relieved from criminal liability. The rationale of paragraph 1 is the maxim el que es causa de la causa es causa del mal causa. He who is the cause of the cause is the cause of the evil caused. Paragraph 2 of Article 4 provides that even if a person committed an impossible crime, he may still incur criminal liability. Possible crime is committed when a person performed act with evil intent that would be an offense against person or property. However, the felony was not produced because there was an inherent impossibility of committing the felony, or the means employed is inadequate or ineffectual, and that no other felony was produced. There are two kinds of inherent impossibility: legal impossibility and factual impossibility. Legal impossibility occurs where the intended acts, even if completed, would not amount to a crime. For example, A with intent to kill B stabbed him several times. Autopsy revealed that hours before the stabbing incident, B succumbed to cardiac arrest. A committed an impossible crime as he tried to murder a dead person. A dead person cannot be injured or killed again. Factual impossibility occurs when unimportant or irrelevant circumstances unknown to the actor or beyond his control prevent the consummation of the intended crime. For example, a man who puts his hand in the coat pocket of another with the intent to steal the latter's wallet and finds the pocket empty. In both cases, the offenders are still criminally liable even if what they committed are impossible crimes. The penalty for impossible crimes is arresto mayor or a fine ranging from 200 to 500 pesos in consonance with Article 59 of the RPC. The purpose of punishing impossible crimes is to suppress the criminal propensities or criminal tendencies.